All right, we move on for now. The centre is mulling introducing a bill on triple talaq. The bill is likely to be introduced perhaps in the coming winter session and the one after that. This comes in the backdrop of the top court's August 22nd judgment that termed triple talaq as unconstitutional, the instant triple talaq as unconstitutional. After that, it's taken 3 months, but a ministerial committee has been constituted to frame a legislation which will then be introduced in the parliament. This news today has, of course, triggered a huge amount of response from political parties, activists, as well as clerics. And we're getting a mixed set of response. But women across board have been demanding for legislation, for stronger laws to bring in some amount of justice for them, to empower them. And this is what several of the women activists that we here at Mirror Now have spoken to have also said, that while the top court may have struck down instant talaq, there is still need for legislation, which is what the government now needs to look into. Meanwhile, senior advocate and former Attorney General Mukul Rohatgi, who had argued against triple talaq in the Supreme Court, has now welcomed the bill, or rather the move that the government is working on a new bill. In an exclusive conversation with Mirror Now, Mukul Rohatgi added that these laws are discriminatory and give women no say in the matter.
Joining us, the former attorney Mukul Rohatgi. Sir, at the outset, we've just learned government is intending to bring about a legislation which will go on to outlaw the practice of triple talaq. Your thoughts, sir?
No, see, it is but natural and a natural corollary of the judgment. Once the judgment says that triple talaq is forbidden, is unlawful, is illegal, and it has equated gender justice, it has brought up the lot of women of the minority community, given them dignity, given them their rights. So you give them a right, so you have to give them a remedy also. So if today a woman is chucked out like chattel or goods, on the ground of this illegal triple talaq, so what will a woman do? She'll go to a police station, whatever, but what will she do? So when there is a right, there must be a remedy. And according to me, it should have even come earlier. But it's a welcome step, and I hope it is passed in the winter session, so that there is fear of God and fear of punishment in people who want to indulge in some such activities. So it's a very welcome and wholesome step.
Meenakshi is joining me for more on the phone line. Meenakshi, take us to some of the key things that the five-judge bench actually said when they struck down instant talaq, because that is the judgment that is actually going to pave way for this legislation.
Well, Tanvi, absolutely. And the one thing that really stood out in that judgment was the fact that there was unanimity, at least in the majority opinion, of 3-2 in the five-judge composition, which found this practice to not just be bad in law, but also found it violative of the right to equality, which is granted to all as a fundamental right in the Constitution of India. That apart, the Supreme Court also found this practice to be exceedingly regressive, and for this practice to continue in the present time, the Supreme Court thought was travesty, and that is the reason it went ahead and without any hesitation struck down this practice as ultra-vires or unconstitutional. And like Mukul Rohatgi there was highlighting for Mirror Now, the reason the government has now taken this step is to bring effect to that Supreme Court judgment, Tanvi. Because remember, by outlawing this practice or holding it as unconstitutional, the Supreme Court gave a right to these women who were also petitioners before the apex court. And once a right had been created, therefore, a remedy also needed to exist for that right being denied to lots of Muslim women who had petitioned the Supreme Court. So, along perhaps for understandable reasons, the government is taking the next logical step towards bringing effect to this Supreme Court judgment, which was a laudable judgment. Tanvi, our viewers will recall, we had covered it extensively as to how cutting across spectrums several segments of society, women in particular, had hailed this judgment because it had sought to correct a wrong that was perhaps being overlooked by clerics, by other people who had some sort of a vested interest. So much so, Tanvi, that when the matter was being argued in Supreme Court, the Muslim Personal Law Board had urged the Supreme Court to keep its hands off the issue, saying that instead of Supreme Court passing a judgment, the All India Muslim Personal Law Board could be looking at some way to reform itself, or rather self-reform. Of course, it's now in the past and the Supreme Court had none of it, and therefore government step is being hailed by many jurists as a step in the right direction.
Yes, absolutely. In fact, the then Chief Justice, Justice Kehar had also said that in many of these aspects, the best thing is for the government, actually, the legislative arm of the country, to come out and bring in a law. And perhaps the government has gotten that message and has begun the process. It's not going to be an easy one. Already we are seeing conservatives, political leaders, clerics creating some noise unnecessarily. All this seeks to do is bring in a law to ensure that anybody who's still practicing instant talaq is punished for that. And if it does formulate a procedure for triple talaq based on the current practice and the Quran, then why should that be a problem for anyone? Meenakshi, thanks so much for joining us. Let's also play out a few reactions we've got on the story.
मुसलमानों की क्यों सरकार को इतनी फिक्र सता रही है? दरअसल वो मुसलमानों को लेकर के या मुस्लिम महिलाओं को लेकर के कोई फिक्रमंद नहीं है, बल्कि ये उनका एक सियासी गेम है, सियासी हथकंडा है, जिसके तौर पर वो इस तरह के बातें कर रहे हैं। वरना इंस्टेंट ट्रिपल तलाक को लेकर के सुप्रीम कोर्ट का फैसला आ ही गया, उसने इसको अनवैलिड करार दे दिया, बात ख़त्म हो गई। इसके बाद फिर आगे बिल लाने की या कोई कानून साजी की ज़रूरत कहाँ बाकी रह जाती है? कानून पहले से बना हुआ है। अगर कोई ट्रिपल तलाक देता है इंस्टेंट, तो उसके खिलाफ डोमेस्टिक वायलेंस का केस बनता है, कॉन्टेम्प्ट ऑफ कोर्ट का केस बनेगा, तो बहुत सारी सज़ाएं ऑलरेडी है। लेकिन उस पर फिर नया कानून लाने जा रहे हैं। लग रहा है कि देश में और कोई मसला ही नहीं है, देश में इतने इश्यूज़ हैं, उन इश्यूज़ की तरफ से ध्यान भटकाने के लिए ये मुस्लिम महिलाओं की तरफ ही हमेशा जो तीर फेंकते रहते हैं।
देखिए, पहली बात तो यह है कि चूँकि सुप्रीम कोर्ट ने तो अपनी बात वाज़ेह तौर पर कह दी है, लेकिन अगर सरकार इस तरह का बिल लाती भी है या कयास है, तो मुझे लगता है कि सरकार को सारे पहलुओं पर गौर व फिक्र करना होगा। चूँकि धार्मिक मामला है और धार्मिक मामले में तमाम धर्म से जुड़ी जो संगठन्स होते हैं, जो धर्म से जुड़े धर्म गुरुज होते हैं, उनके साथ भी उनको इस पर पूरी चर्चा करनी चाहिए और चर्चा कर कर फिर किसी फैसले पर या किसी बिल की तरफ बहस पर आना चाहिए।
Senior Advocate Sanjay Hegde on the phone line. Mr. Hegde, thank you for speaking to us here on Mirror Now. Do you believe that this would be a good opportunity for the government to not just bring about a law against instant triple talaq, but perhaps also explore the possibility of a larger legislation when it comes to some of these family laws?
If the government of Free India could legislate on Hindu marriages and divorces, there's no reason that it cannot do the same with regard to other communities. Laws are made for all Indians, and if you take into account the peculiarities of essential religious beliefs among various communities and draft laws accordingly, you would not even be violating religious freedoms. So there is nothing in the Constitution, as I can see, which prevents the government from framing a proper law. Now, the question for uniform civil code is something else altogether. Uniformity, conformity, or majoritarianism, those are various value judgments which may run into constitutional problems. But if there is a law which is specifically made for Muslims in order to regulate the method of divorce or the registration of divorce, I don't see a problem, because way back during the British India in the 1930s, we had the Sharia Act being passed, which is more or less the basic law among various Muslim communities in India. There is scope for the law. The law can be religion specific, but if you insist on certain laws conforming to one particular idea of India or one particular idea of Bharat, there may be other problems, because then
the route of uniform civil code. I don't want to go down the route of Uniform Civil Code either, Mr. Hegde.
Let me illustrate. Then can we have a law regulating the Jain practice of Santara? Or there would be other practices in other religions also, which may not be particularly acceptable to modern social mores. So, once you go down the legislation route with regard to one community, you will find similar demands for legislation in various other communities. And is there a government with political will which will say, irrespective of anything, we are going to make the law and implement it?
Yes, absolutely. In fact, that was the point that I was trying to also get to, is about the political will. Now, I was just speaking to representatives of the Bharati Muslim Mahila Andolan, and they have been fighting for decades now when it comes to gender justice and women empowerment and rights for these women, especially when it comes to age of marriage or the practice of talaq itself. Those are the issues. They've actually even drafted a law already and sent it their suggestions to some of these politicians and MPs and women MPs in the parliament. But do you believe there is actually a political will to bring this to fruition?
I can't speak for the government and for its political will. If a government had the political will to legislate at all times, I don't think it would have cancelled the winter session of Parliament. We have, over the past few years, basically taken away from Parliament the privilege of debating over legislation. Anything which is urgent sometimes comes as an ordinance or is sometimes pushed through Parliament through dubious procedures like money bills. If you read our constitutional history, if you read the early Parliament debates, each and every section was debated over. Today, if legislation is vital, it's just pushed through in a hurry. If it is not vital, it just lies in some parliamentary committee or the other. Political will has to be ascertained from the speed with which a bill moves.
Sanjay Gray, thank you for taking the time out to speak to us here on Mirror Now.